did they do it? What happened? Put us back to where.
SJC-11281, Commonwealth versus Robert Morganti.
Thank you.
All right, let's proceed. Good morning.
Good morning, Your Honor. I'm Attorney Don Harwood on behalf of the defendant appellant Robert Morganti. This is an appeal of a new trial motion, excuse me, in a first-degree murder case. And as the court is well aware, there are important issues to be resolved in the case. In this case, Judge Giles held squarely that there was a closure of the courtroom in Brockton Superior Court in June of 2003. She said that this occurred and found that this occurred pursuant to a court policy of exclusion in Plymouth County and in Brockton in particular at the time. In her decision denying the new trial motion, she specifically held not only that there was a closure, but that the defendant had neither been advised of his right to a public trial, nor had he waived it, because he hadn't been advised it. If he had no knowledge of the right, how could he waive it?
It was pre-Lavoie.
It was pre-Lavoie. There was also both an affidavit and testimony from trial counsel that he had no strategic reason to have not objected to the closure.
Who was trial counsel again? Was that Mr.
Attorney Kevin Reddington.
Kevin Reddington?
Yes.
Okay, but
Not an
probably one of the most
inexperienced lawyer.
One of the most experienced
Yes.
litigators in Massachusetts.
Yes. And what the trial judge did in this case was she denied the motion on the ground after having found in defendant's favor both on closure, waiver, and the fact that there was really no other way to go in terms of affirming conviction, that this was a, quote, de minimis closure. And what she said was the jury selection was 79 minutes long, and so this was of short enough duration that it was de minimis. And she relied upon a Second Circuit case out of New York, United States versus Gupta, which at the time similarly held that. Now, Gupta, as the court is no doubt aware, then sua sponte reversed itself and said in this case, in Gupta, if you're excluding everybody from the entirety of jury selection, which is what happened here, it can't possibly be de minimis. So we come before this court now with a ruling affirming the motion on de minimis, relying upon a Second Circuit decision which then reversed itself.
But what do we know about, this is the second session courtroom, right?
Yes.
Which is a pretty small courtroom, correct?
For a
I mean,
two-defendant case,
I
it
say
is.
that because in the other case, Alibor, there's findings by the same judge about
Right.
that courtroom. So
But the first session courtroom in Brockton is a pretty big one. And there were no Waller findings. There were no reasonable alternatives considered. In Brockton, you can ask and you can be transferred to a session that can easily accommodate a venari of this size. As well, this was not a two-defendant case. So whether or not the second session would have held all, I would suggest that it certainly probably would, because it's not a two-defendant case, but no alternatives were considered whether you could transfer to the first session.
Now, Mr. Reddington, I believe, said he knew that there was this practice in Brockton of closing the courtrooms to jurors.
He said that he knew of the practice and that he went along with it.
Okay, now
But he did say also that it wasn't until Owens that he appreciated the impact of Owens in terms of jury selection, and it was after the Owens decision in 2007 that he then, for the first time, began objecting to this.
Right, well, I understand
And in
that.
his affidavit, he indicates under oath he didn't and was not aware of the right as it
Yes,
applied to
but he
jury
testified,
selection.
so we really have to consider his testimony, not his
And he
affidavit.
testified that it was not until after 2007, and as well his involvement in the Cohen case in a pretrial capacity, rather in a hearing capacity, that he began to object. So going along with the...
What do we know, though, about, I mean, play out. Imagine he actually had objected. What would he have gotten for that?
He
What
would have
be the-
gotten a trial in the first session.
So they would have had to
with
change?
members of the public,
They
including
would
his
have
family
had, I'm
present.
sorry, stop there. Do we know whether the first, I mean, do we have any fact findings as to whether the first session was available? Whether was there, I mean, I assume the first session was being occupied.
No, it was not considered under a Waller analysis, so no.
Okay, but do we have any findings after the fact as to what the, I mean, what realistically an attorney in the position of Mr. Reddington would have considered to be the consequences of having asked for that, because an attorney has to deal with the possibility you need to be careful what you ask because you may get it. So I'm trying to play out what would have happened if he had asked for it and gotten it. Would that have, what would have been the practical consequence of that?
The practical consequence would, the judge would have had to make Waller findings. The judge would have had to have considered reasonable alternatives, and reasonable alternatives, if the courtroom had even been unable to accommodate, and I'm not conceding that, might have been to transfer to another session. But the bottom line here is Attorney Reddington said he was, at best for the Commonwealth, was, quote, going along with the practice, which is not a conscious decision to forego a right. And there was a case this summer out of Middlesex, Commonwealth versus David Coutu, where the same thing happened, and the judge specifically found, with respect to the Lowell Superior Court, kind of going along with the flow, like every other attorney, does not mean, A, that you are making a strategic decision to waive a right, and it's not making it, it's not like you're aware of the right and giving it up for some gain. Here,
Does it make your conduct below what we would ordinarily expect of a normally fallible lawyer?
yes.
Really?
In Owens,
Really?
as this court is aware,
All the lawyers in the Commonwealth trying cases in that county essentially went along with the practice for whatever reason.
some lawyer, it appears that many did. And in Owens, there was a
So
finding.
the standard is a standard based on our own professional norms at the time.
It's based upon the fact that Waller, in 1984, said that this was something that courts had to do. They had to have Waller findings. Attorneys.
But lawyers don't have to, I mean, lawyers don't have to object. Lawyers can object. They don't have to object. They don't need to require that all of this take place in the manner you suggest.
But if lawyers are going to be charged with that knowledge, like as in Owens, the federal court found that counsel was ineffective and should have known at a 1997 trial.
Well, that's what the
That
federal court found.
proceedings, yes.
Federal court found.
That's
Right, and I've relied upon Owens in my papers, and Owens is something that this court has cited approvingly in Commonwealth versus Cohen.
Of course,
And
the
in
pro-
Owens,
But the problem with Owens is it's a federal court habeas corpus review of a federal court conviction. And the standard is different when you have federal habeas corpus review of a state court conviction. And it seems to me in all of the cases that you're, at least the important cases that you're relying on, there has been an objection by trial counsel in every single one of the cases. Do you have a case in which there was no objection and the issue came up and there was structural analysis review applied?
yes.
What case?
Well, Owens, for one, I think what Your Honor is saying is you have in the past jumped to structural error reversal if there's an objection, like in Commonwealth versus Cohen.
Yeah.
The cases that consider this in the context of ineffective assistance of counsel are Owens. In Owens, the court said, if counsel is ineffective,
the district court.
well, and the First Circuit Court of Appeals said, prejudice is presumed
But that,
as a matter of law, because the whole point of Supreme Court jurisprudence is with structural errors, you can't prove prejudice. So Arizona versus Fulmonti identifies which rights are structural errors, among which is the public trial right.
But Coleman versus Thompson says that Fulmonti does not apply in circumstances where there has not been preserved error. And it specifically refers to Fulmonti.
But there's no Supreme Court case that goes against Owens. Owens is certainly persuasive, if
Owens
not
is-
controlling, of a federal constitutional claim.
But Owens
Of this-
it's in a different context. It's the context of federal habeas corpus review of a federal conviction. We have a state court conviction, and we are on collateral review now. And do you have any case which says that your client is not in a situation of default right now, and that we don't have to apply, or that we must apply in a situation of default, we must apply structural error analysis?
If there's procedural default, and
You have a
if the,
case.
and if the defendant has alleged ineffective assistance of counsel, Owens says it, Commonwealth versus Barron, in the Massachusetts Appeals Court, relying upon Owens says it. I've also cited the majority view of the circuit courts of appeal.
But they're all federal, but they're not state court convictions. They're federal court habeas review of federal convictions. It's a different standard.
I don't see how the analysis would be any different. It's an
There's a-
ineffective assistance of counsel claim.
There's a whole principle of comedy that's involved. That's not
Yes.
in review of state court convictions that does not apply in federal habeas review of federal convictions. If what you say
It
is
should not
true-
alter the result here at all.
But it
Owens
does.
should be controlling.
If what you say is true, any defense lawyer in the face of structural error can just remain silent and wait until the jury comes back with its verdict. If it's an adverse verdict, he can play the trump card, knowing that it's guaranteed. The only way we can have an orderly process of criminal jurisprudence is if there's an objection made, so that the trial judge can address the problem at the time.
But here you have an attorney admitting he had no tactical reason to do this, whether you can consider this under Safarian or Owens.
It's ineffective assistance.
You have, unlike Lavoie, you have an attorney admitting he didn't have a strategic reason to forgo objection. And this court has to grapple with, it's not like Lavoie. Here you have to grapple with the fact you have an oversight of counsel. I would say, based upon the case law, he's admitting essentially ineffective assistance, so it's not like Lavoie. And then you have to grapple with what result flows from that in terms of prejudice. And I think that where you have a structural error is every bit offensive in a state proceeding as it is in a federal proceeding. Cohen, the decision says structural error with respect to a public trial right.
And the Supreme Court has said recently in Melendez-Diaz that the states can establish their own procedural rules for the failure when evaluating federal constitutional claims, for evaluating whether or not the issue has been properly preserved. And in this case, the issue was not preserved.
Then you have to consider, as we have argued here, that this was ineffective assistance of counsel. And because this was pre-Lavoie, the judge didn't make findings on procedural waiver. She didn't hold that there was a procedural waiver here. She focused on whether there was a substantive waiver of the right, and she found that there was none.
But there was waiver here because the issue has not been raised. It was not raised in the direct appeal or the motion for a new trial that came up with the direct appeal.
Well, the direct appeal argument that the Commonwealth makes is quickly disposed of. This court made clear in Zinsser that with respect to a first motion for new trial, which this is, especially where you have a record that's not developed, there is no waiver if you bring the motion for new trial in a first motion after the appeal. That's crystal clear. In Commonwealth versus Novo, you affirmed a conviction where ineffective assistance of counsel issue was raised, and you said at the end, but you can revisit this in a motion for new trial.
But
So-
there's different kinds of waiver. It's
There's substantive waiver or procedural default.
It's
and then
unpreserved error, and it still comes up under the substantial risk of a likelihood of harm.
If it's procedural waiver, and you find that, even though Judge Giles didn't go there, then you have to examine it under the ineffective assistance of counsel claim. I have to show cause and prejudice. And with respect to a structural error, like the public trial right, there aren't that many of them out there, but this is one of them.
Well, another one is failure to give a reasonable doubt instruction. And we have said in Maines versus the Commonwealth, and other state Supreme Courts have said this, and it's been upheld, that if the error is unpreserved on a failure to give a proper reasonable doubt instruction, we don't apply the structural error analysis. In order to apply structural error analysis, it has to be preserved.
Mr. Harwood, you're going to have to wrap it up.
Okay.
You can summarize if you'd like.
I would just summarize by saying the judge held that there was no substantive waiver of the right. The closure could not possibly be de minimis words for the entirety of jury selection. There are no findings by the judge that there was a procedural default, and she didn't reach the claim of ineffective assistance, thinking that there being no waiver, she didn't need to go into that analysis. And under Owens and numerous other circuit court opinions, where you have a denial of the public trial right, prejudice is presumed because the Supreme Court has said it's impossible to prove prejudice. And if the court adopts a different analysis, there would be an anomaly because it would be easier to prove error with respect to a non-structural error, and it would always be impossible to prove prejudice and error with respect to a structural error. So in light of Owens, which I suggest to the court is controlling, I would ask that the conviction be reversed. Thank you.
Thank you, counsel.
Good morning. May it please the court, Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth. I'd like to begin with waiver. My brother noted Judge Giles didn't go there, but as noted by this court in the earlier argument, this was pre-Lavoie. Judge Giles was in kind of a tough spot because she's the trial judge in Alabord and the trial judge in Morganti. Both were 79-minute closures. She found closure of the courtroom in both of them by exclusion of the family members by the court officers. Now, what the procedural posture of Alabord is relevant in this case because of where the judge found herself. In Alabord, in 2008, prior to Cohen, prior to Presley, but with Owens as not as binding precedent, but as persuasive authority, that was there. She made a finding of waiver by failure to object through the actions of counsel in Alabord, and you see that in the appeals court Alabord decision. And she got reversed. And the Alabord court in the appeals court said, you have to have a personal knowing waiver by the defendant, which we now know is not correct under this court's decision in Lavoie. But they said that to Judge Giles, and they sent it back for findings, so she can't make that finding that she has previously made again in Alabord, and she starts considering Alabord. And then she gets Morganti in a motion for new trial, and she has to make a similar analysis in that, and she actually cites to Alabord in her findings. So the judge could not, when she was deciding the motion for new trial in Morganti, she could not apply this court's analysis in Lavoie, because Lavoie hadn't come out yet, and because she'd already applied a very similar analysis in Alabord and got reversed. But if you look at her findings, I would suggest to this court that it is readily apparent that this is a waiver, based on her findings and based on the evidence presented to her, that this is a waiver.
I mean, when
and it's
she
like,
says that Mr. Reddington was certainly aware of the Sixth Amendment public trial right, that part.
yes, that's at Defendant's Record Appendix 105. She says, although knowledgeable of his client's right to a public trial, Attorney Reddington lodged no protest to the clearing of the courtroom. And in fact, Attorney Reddington talked quite a bit about his knowledge of jury selection. And the judge credited his testimony, you'll see that at the motion for a new trial transcript, volume 2, that's where his testimony is, at page 26. She says, whose testimony I trust implicitly. So she credited what Attorney Reddington said. And so I suggest that this court is in the position under Commonwealth versus Cruz and Commonwealth versus Va Meng Zhou that you can apply the correct standard of the law under Lavoie to the findings of the judge as supplemented by Attorney Reddington's testimony. So what is his testimony? Where is this waiver that the Commonwealth is asking this court to find and rule? He said he was aware of the practice of the court officers clearing the courtroom. And by the way, he is very experienced. He's premier criminal defense attorney in Plymouth County. He tried 75 to 100 trials in the Brockton Superior Court alone at the time of this trial. He's highly experienced. And he said this closure of the courtroom, it was something we all did. Motion transcript 2, pages 10 to 11. He did not begin objecting until the Owens federal court decision in 2007. That's in April of 2007. And of course, he goes on to explain that he was very good friends, best friends, talked to on a daily basis, Attorney Richard Egbert, who was the trial attorney in Cohen in the summer of 2007. And he was actually on the phone with him every day during that trial. So he became aware of this issue out there in 2007. And what he had testified to in the motion for new trial is that he didn't think it had any legs. He didn't think it was a good legal claim.
Well, let me ask you
But that's
this,
when he
though.
began making objections. Yes.
But his affidavit certainly says, and I have not read his motion testimony, but his affidavit certainly says, yes, I was aware of the public trial right, but I didn't really think that it applied to jury impanelment.
Well, I think you can
And
look
I
at...
don't know whether that came out in the testimony as well, or what did he do?
Well, I'm not 100%, my memory is not 100% whether the affidavit was offered as evidence, but it's part of the record. But he explained what he meant by that he didn't think it was a good claim, he didn't think it had any legs, but he began objecting after Owens, and he continued to object after the Cohen trial. But until then, he would participate in this courtroom closure, whether it's a practice or a custom. He would tell family members to wait outside, although he had no recollection of doing so in this case. Both he and the defendant knew that the defendant's family was outside. He was not just aware of the practice, he was aware of the explicit closure that they were standing outside in the hallway, and that's actually the defendant testified and said that he could see his sister through the window in the door.
Well, what are we to make of the Supreme Court statement in Presley versus Georgia that the right to a public trial includes the right to be present of the public and the defendant's family and relatives and friends to be present during jury voir dire, and that's been the law since 1984. In 2001, Justice Sussman made a statement in Commonwealth versus Horton to the effect that this should be open to the public. At least 1984, or at least 2001, probably even 1984, there's no question that this is a public trial right.
Obviously, public trial right has two constitutional provisions. There's the First Amendment and there's the Sixth Amendment. One's for the public and one's for the defendant.
Well, in Presley, they said,
Presley-
the Supreme Court said under the Sixth Amendment, it's well settled. It's
Right.
been a constitutional right since 1984.
Presley was relying on Waller, which is pretrial suppression hearing, and it was relying on press enterprise, which is the First Amendment. And the remedies that it imposed, the Sixth Amendment structural error is
Yeah, but that's not my
reversal.
question.
Exactly.
My question is, are we to take the Supreme Court on take its word at face value that this has been established law since 1984? Can we disagree with that?
The Commonwealth's argument is that, yes, you can disagree with that.
Well, I'm not going to do that.
Right. You can disagree with that because it's not a full analysis. It's just assuming that that Waller means this applies structural error to jury selection, and that it gloms together First and Sixth, and that wasn't the law before. But in this case, the Commonwealth acknowledges that the Cohen and Presley cases came out during the period of certiorari, and so when Berea came out, and noted that 90-day period for certiorari before a decision becomes final, the Commonwealth was, I had to acknowledge to Judge Giles, I'd been making a retroactivity argument in this case, and it didn't look like that would hold water then because of the period of certiorari, because I was 45 days short or something like that.
Isn't your best...
But what I do, I'm sorry.
Oh, go ahead.
What I do note is that there is no case, not from the U.S. Supreme Court, and this is not in Presley, Presley is a preserved error, not from this court, no case, with the exception of Owens in the First Circuit, that says an unpreserved error on Sixth Amendment public trial right gets structural error analysis reversal per se.
Yeah,
Owens stands alone.
But that's under federal habeas corpus review of a federal conviction.
Exactly, it's entirely distinguishable.
Isn't your best argument that, look, even if this is error, and it probably is, it's unpreserved error, and we should review it under the substantial risk of a miscarriage of justice standard. And
Yes.
they have to show, the defendant has to show prejudice.
Yes, whether it's unpreserved error or whether you view it as ineffective assistance of counsel or whether even you're viewing it as trivial de minimis, it's substantial risk analysis.
Well,
I
if
mean,
it's
but
ineffective
the-
assistance of counsel, that's not unpreserved.
I'm sorry?
Ineffective assistance of counsel is not unpreserved.
Yes, but when you're showing ineffective assistance of counsel, you have to show at least a substantial risk of a miscarriage of
But
justice.
then doesn't that take you right back to the fact that how do you show prejudice? Because it's structural error. I mean, I don't know where that...
But this court distinguished Owen's analysis on that in Lavoie,
I
saying...
know, but we didn't really have to reach it because the decision was that it was a strategic tactical decision.
Well, but you did... I'm sorry, go ahead.
In Maines versus the Commonwealth, there was review of structural error under a substantial risk of a miscarriage of justice where there was a deficient reasonable doubt instruction. And my recollection is that we analyzed it under the substantial risk of a miscarriage of justice standard, and we looked at things like the strength of the case against the Commonwealth or against the defendant, and we apply a traditional substantial risk analysis. There has to be
Yes.
some showing of prejudice if the issue is unpreserved.
Yes, that's my recollection of the case as well. And so the Commonwealth's argument, I think if I could summarize it, is that the judge made sufficient findings for a waiver here. So this is both procedurally waived and substantively waived. And so if you review this, you should review it for substantial risk. Also, the substantial risk analysis really it is very similar, I would think, or at least it would include some of the same factors that the judge decided when she was saying this is trivial de minimis. This is 79 minutes out of a 10-day trial.
The entire impanelment, though.
It is the entire impanelment.
You can't do that.
People
though.
who are excluded they have an obstructed view through the windows. Like Rogers, there's an open door, and
Yeah, go ahead.
and that nobody complained about it for 7 years. It wasn't important to them. And so I want to point this court to Levine, which is the United States Supreme Court case, which predated Waller and Press Enterprise. And it says, due regard generally for the public nature of the judicial process does not require disregard of the solid demands of the fair administration of justice in favor of a party who, at the appropriate time and acting under the advice of counsel, saw no disregard of a right, but raises an abstract claim only as an afterthought on appeal. That is still the law, and that's essentially what you said in Dyer. And I'm asking this court not to change the law. The defendant is asking you to change the law and to say that structural error, reversal per se, applies in every case where a defendant has failed to preserve his rights. The U.S. Supreme Court has not required you to do that. It did not say that in Presley. This court didn't say it in Cohen. Those are cases where people preserved their rights.
Now, are you conceding that counsel was ineffective for failing to object?
No, he testified, and you can look at his...
We get to the issue of structural error versus miscarriage only if we find that counsel was ineffective in failing here to object.
Right. If there's a substantive waiver of the right by counsel's actions, then you don't have to consider the issue at all, except to say, was he ineffective when he did that substantive waiver?
And can we do that analysis without the judge having made findings as to what would have happened had he objected?
Yes, because he said that he wanted, they did an individual voir dire at sidebar, They benefited from it, just like Horton. He said that he would go with the flow, not just to go with the flow. He went with the flow because he knew of the small configuration of the courtrooms. He never tried to change the practice through his objection in any other way, just like Lavoie. And he did it because he felt there was a need for an orderly impanelment process. His reasoning,
What he says?
yes, that's a motion for new trial transcript 2, page 20. And then the fact that it was his consistent practice was at 23 to 24. And he was acting just like all the other attorneys. Attorney Krauske testified. He's very experienced as well, particularly in the Brockton area. And Attorney Darrell, who was the attorney in charge at CPCS, supervised all the attorneys there. Between them, they'd done hundreds of trials, and they never objected until Owens and Cohen. And the reason they never objected, according to Attorney Reddington, is not just that it's his usual practice, which was one of the considerations in Lavoie, but also because it helped the impanelment process, and also because the courtrooms are small. And so we don't, to get back to your earlier question about what would have happened, in this case, the judge did not make any findings about what other courtrooms were available and what the sizes of the courtrooms were.
Right, or what the size of the veneer was, as she did in Albor.
Right, but we do have testimony about the size of the veneer. The defendant testified that his memory was the courtroom was packed. We know that
Packed meaning standing, meaning standing room?
he said the courtroom was packed. The record shows at least 45 jurors were questioned, and Attorney Reddington estimated it was somewhere around 100 people in the courtroom.
In the courtroom.
Is the ineffective assistance claim directly before us, would you say?
On collateral appeal, yes.
Here?
Yes.
It's been litigated below and is here for us?
Yes. So-
Although the judge didn't reach it herself, is that right?
She didn't. She focused on de minimis and trivial, I would suggest because of the position she was in because of Alabord from the appeals court. So it asked this court to find a waiver. You can, based on the record here, you can credit Attorney Reddington's testimony as the judge did and look at her findings, and you'll see that this is waiver just like Lavoie. And I'm asking you to find that no new rule is necessary about how you view unobjected to, unpreserved claims, in which case you should follow the U.S. Supreme Court in Levine saying there's no reason to change it. That's consistent with this court in Dyer. So I'm asking you not to change the law and to affirm the denial of the motion for new trial on grounds that were stated as well as grounds that are different. If there are no further questions,
Thank you, counsel.
thank you.